Are we all here? If you can please announce who are in the halls this afternoon.
Madam Speaker, currently present in the session hall are yourself, Vice Speaker Cruz, Senator Palacios, Senator Agun, Senator Tenorio, and Senator Blas. There is no quorum.
Thank you very much. Sergeant at Arms, can you please call? We need 2 more members to make a quorum. Email atento na Legislature ng Guam is called to order. I'd like to ask Senator B.J. Cruz if you can lead us in prayer.
Let's rise and bow our heads. Dear Lord, as we come together in this second month of the year, we ask your guidance as we prepare to deliberate over legislation that will affect our people. We ask you to give us the wisdom to make sure that what we do is actually in the best interest of our people, and that the decisions that we make and the votes that we make will enhance the quality of life for all the people of our island. In your Son's name, amen.
Thank you very much, Vice Speaker Cruz. I'd like to ask Senator Palacios to lead in the recitation of Inifresi.
Inifresi, gini mas tat kilo, gihinasoko, gimas tat kalom, gikurasonhu, mas figo na nina sinyahu, ufresin maisajo, para baihu protehi, janu defendi, ihinengi, ikultura, ilingwahi, i-airi, i-hanum, janitano chamoro, ni irin syokko, diretso, gininazu stata, esti u hafidma, gihilo i-biblia, jan ibandiraho, ibandiran guahan.
Senator Frank Blas, if you can lead us in the Guam hymn, and Senator Frank Uggan in the national anthem.
Panogita moru purita nota kantai matunanya gitoru ilugar harai onra harai gloria abiba isla sen para harai onra harai gloria abiba isla sen para todo y tiempo y paz para hita zangin mi langit na bendición contra peligro na pansapuhan Zus protegi Island Guam contra peligro na pansapuhan Zus protegi Island Guam.
Oh, say, can you see by the dawn's early light was so proudly we hailed at the twilight's last gleaming, whose broad stripes and bright stars through the perilous fight. For the ramparts we watched were so gallantly streaming, and the rockets that flare, the bombs bursting in air, gave proof through the night that our flag was still there. Oh, say does that star-spangled banner yet wave o'er the land of the free and the home of the brave?
Thank you very much. Can the clerk please take a roll call?
Senator Ada. Senator Agun. Senator Blas. Senator Calvo. Senator Cruz. Senator Espaldon. Senator Guthertz. Senator Munya Barnes. Senator Palacios. Senator Pangilinan. Senator Respicio. Senator Taitagui. Senator Tenorio. Speaker Wampat.
Present.
Madam Speaker, wish to report there is a quorum.
Thank you very much. Senator Respicio,
Thank you very much, Madam Speaker. I move that Senator Spaldon as well as Senator Calvo be excused from today's session.
on that motion, then without any objection, so ordered. And approval of the legislative journal.
Thank you, Madam Speaker. I move for the approval of the Legislative Journal dated February 16, 2010, subject to correction.
Without any objection, so ordered.
And Madam Speaker, I wish to report that there are communications and petitions, and I move that these communication and petitions be appended to today's session journal.
On that motion, without any objection, so ordered.
Madam Speaker, there are messages from Imagalahin Guahan, and I move for the same that they be appended to today's session journal.
On that motion, without any objection, so ordered.
Thank you, Madam Speaker. The same with standing committees. I move that these reports be appended to today's session journal.
Without any objection, so ordered.
Madam Speaker, there are no reports of select committees, so if I may proceed to the introduction and first reading of bills and resolutions. I move that Bill number 332-30 COR, Resolution 284-30 COR be given its first reading.
On that motion, without any objection, so ordered.
My first motion, Madam Speaker, dear colleagues, if you see on page 2 our session agenda on the second reading file, there are 24 bills that made it on the agenda, but in the interest of trying to be more efficient and accommodating, only items number 5, 6, and 7, if you'll follow me, 9, 11 and 12, 13 and 14 currently have committee reports filed with the clerk. My motion, therefore, is that when we get to this bill in the second reading file, any bill, if the committee report has yet to be filed with the clerk, or if the author needs additional time because additional information is required to make a better presentation to his body, I move for the customary motion that these bills be set aside. It doesn't lose its place, but it comes back when the author signals you, Madam Speaker, that they are ready with their bill.
On that motion, then without any objections, so ordered.
At this time, I would yield to any senator who would like to make a motion for any of these vetoed bills, and I'd ask that you recognize me after.
Is there anybody under motions of any vetoed bills? There being none, so legislative concurrence.
Thank you, Madam Speaker. From the item 1 from the Committee on Rules, Natural Resources, Federal, Foreign, and Micronesian Affairs on the appointment of Mr. George Lai to serve as a member of EPA Board with a recommendation to do confirm, I move that this be placed in the voting file.
Without any objections, so ordered.
From my same committee, Madam Speaker, on the appointment of Mr. Robert Perron, I move that he be placed in the voting file to be a member of the Guam Environmental Protection Agency Board with the committee's recommendation to do confirm.
Without any objections, so ordered.
The same motion from the same committee, the nominee being Dr. Thomas Poole, to serve on the same board with the same recommendation to confirm, I move that it be placed in the voting file.
On that motion, without any objections, so ordered.
And on the last legislative concurrence from the same committee on the appointment of Johannes Temmingill to serve on the same board with a recommendation to do confirm, I move that this nominee be put in the voting file.
Thank you very much. Without any objections, so ordered.
Thank you, Madam Speaker. There are no items on the consent calendar, and so. Madam Speaker,
One more from the Committee on Education.
from the Committee on Education, and we just received the committee report, I understand, Ms. Rosa Palomo for the
The Academy Charter Council.
Academy Charter Council.
On that motion, then, without any objections, so ordered.
Thank you, Madam Speaker. We're on second reading. Wait. Huh? Yeah, and the clerk has reminded me, Madam Speaker, that I make a motion that any resolution introduced that's congratulatory or condolence in nature that's introduced during our session be automatically adopted, and that the legal counsel and the clerk work with the sponsor for the preparations of these documents, and that all members of the legislature be co-sponsors.
On that motion then, without any objections, so ordered.
And I thank you very much.
Thank you very much. We are now in second reading file, and I recognize Senator Palacios on the bill number 208-30.
Thank you, Madam Speaker. Madam Speaker, I move that Bill 208-30 be moved to the reading file for purpose of discussion. And this is an act relative to clarifying the restrictions established on the recruitment or compensation of government Guam personnel above Step 10 of the compensation schedule through amending Section 6205.2 of Chapter 6, Title 4 of Guam Code Annotated. If I may, just briefly. This is the same bill that this legislature dealt with, the last legislature dealt with. And at the time, this is an issue at the Office of the Public Auditor where 3 individuals were affected, excuse me, who were hired at above Step 10. And later on, it was determined that that is an improper placement of the steps. And upon determination, and it even went to court, I guess there was a ruling there, a decision that indeed they were given the above Step 10 improperly, and that the OPA has no authority to do so. And so the employee were affected, and this bill is actually to amend the effective date, not the granting for the more or less the forgiveness of the having to pay back 17,000 times 2 years for one individual. So the date here is actually an amendment of the when it will be effective. And when this was passed in 2008, it actually says here that upon the passage, or with the effective date down there, upon the passage of the fiscal year budget of 2008, that it also be effective. But then we realized that it had to go back to affect only those hired at Step 10 after October 1st, 2007, and not after October 1st, 2008. And so that is the only one, and that will correct what this legislature had tried to address in the past legislature. And so that is just an amendment of the effective date to go back to that date, so that those hired after that, then it will be affected by the restriction. And those hired before that, which are the three individuals that were affected by the OPA, would not be affected by the new provision. So that is, and I hope that my colleagues try and remember what this is all about. And again, this body had agreed to do what the purpose, Bill 208 intends to do, except that the effective date we adjusted, so you'll be able to completely now address the issue and settle it. Thank you, Madam Speaker.
Thank you very much, Senator Palacios. On the motion, I recognize the Vice Speaker on Bill 208.
Before I speak on it, I'd just like a clarification. Would this comply with the court order and the decision in the court order?
Would the author like to yield?
Actually, this would, I think, because the court order says that at the time of hiring, it was determined to be improper based on the, I think there was the Simizu amendment back then on the fiscal year 2008 budget. But with this amendment, with the new date, it would actually address the court's, of course, the court's decision based on before the amendment. So in other words, with this amendment, it would satisfy I guess, remove that point on which the court makes a decision that the employees are improperly given the step 10 and must pay back.
Vice Speaker, do you have another question, further clarification?
I don't get a sense of the answer of whether or not we are. The problem that I have is that the Office of Public Accountability is by the title, Office of Public Accountability. And if we cannot hold them to be accountable for their mistakes, how do we expect that their rulings about everybody else's non-accountability is to be taken seriously if we're just going to legislate to forgive everything that everybody does?
Is there anybody else that you'd like to address your question to?
No, it's just I'm trying to get the sense of this.
So
and
you
whether
don't need Senator Palacios then?
No, I
Okay,
don't.
thank you then, Senator Palacios. You may continue.
I object to this. This does not comply with the court order, and it is just telling the Office of Public Accountability, we'll cover our eyes and we'll forgive everything. If you can forgive 3 individuals in one agency, especially at the Office of Public Accountability, then we should do it for all 12,000 employees throughout government. I ask my colleagues to please think about this because, I mean, I'm not trying to take the hide of the 3 persons. If anybody should repay that amount, the public auditor should on her own be held accountable to returning that money. It was her mistake. It was not the employee's mistake. And I really object to any attempt to whitewash over it with this bill by changing the date and pretending this thing actually complies with the court order. It does not. And we expect that we're going to get accountability from the rest of the government. We've got to hold the Office of Public Accountability first to comply and be accountable for their actions. Otherwise, let's just hang it up and forget the rest of it. Thank you.
Thank you very much. On the motion, Senator Pangilinan. You change your mind?
Thank you very much, Senator Madam Speaker. Madam Speaker, I certainly share some of the, or actually I share all of the sentiments of the retiring Speaker, with the one exception, of course, that I'm going to just take a different tact on this, but it certainly is much like what happens when a husband decides to not pay taxes or evade taxes, and then he has a spouse who's linked to him or her, and then they come after you, and there's no innocent spouse provision. And I think that that's what we find has been done here, in which the public auditor's action, not the office, but the public auditor herself, her action in the recruiting of the individuals that she did for the office did not have an innocent spouse provision. And it was even kind of, it's a little hard to take because of the fact that the public auditor was so adamant that she was correct and decided to go to court and everything else. And then when the court ruled against her, the solution was, well, change the law and fix it so that I'm not held liable or accountable for my action. But the action that we're trying to prevent here, or at least I'm trying to prevent, is the effect on the innocent spouse. In this case, the staff that were hired in good faith, that left positions in good faith, accepted offers that were made as being true and correct and legal without any protection whatsoever. And when it came down to the final decision, we find that these individuals who left other positions within our community, some actually resigned from positions off island and moved to Guam to be back home with family and contribute to our community because fortunately or unfortunately, it is that one single individual that continues to remain within the office of the public auditor, who sacrificed a career and additional pay beyond what she was offered and accepted and moved to Guam so that she can use the skills she has in her position with the Office of Inspector Generals and the federal government as an auditor to do what is necessary to contribute those skills to making sure our government operates openly and honestly. And she has done her job tremendously and carried out her duties, and it is the actions of others that have placed her in jeopardy and placed her financial security in jeopardy with regards to the position she has and the resulting effect of the decision that was made on her financial security, in that the solution to the problem that was created by the action of the public auditor in this case was that she would have to repay the money that she was paid, in which she accepted in good faith, performed the work under those provisions of employment, and did so admirably well. And what we are trying to do here is it is after the fact, put in this innocent spousal protection, so you might want to term it like that, and shelter the financial harm that will come to this one single individual who continues to remain with that, and who should bear the burden of that decision, And I mean, we had this huge move to Office of the Public Accountability, and when we find that something went awry, the accountable thing to do is change the law so that we appear to follow it. And, in one of the solutions offered was take it out of my budget. Well, we had a provision in some of the public laws that it comes out of the director's salary if, for example, they don't file the reports required or they don't act and protect the fiduciary resources and responsibility that they have with regards to the financial resources of this government. So I'm a little, it's a hard pill to swallow for me to look at this, and if we could isolate this, and we probably could, I would have no problem at all providing that innocent spouse protection to that individual because of the nature and the good faith that she exercised and accepted those positions. But somebody has to be held accountable, and who will that be? Well, in this solution, nobody is going to be held accountable except this legislature that's willing to kind of bend the rules a little, or not really bend, but just change the law so that it's not broken after the fact, as if it was never broken. And so it's a dilemma for me, but again, for me, I'm going to continue to look at this and think about it, but I certainly want to do what I can, find a way to provide what I would term to be that innocent spouse protection to this one individual who has acted in good faith and relied upon representations made from people in authority who should have known better. Thank you.
Thank you very much, Senator Pangilinan. And Senator Respicio on the motion.
Thank you very much, Madam Speaker. Madam Speaker, I too certainly share the sentiments of Senator from Pt. and especially the sentiments of the retiring Speaker. And I've been following this issue very closely. During this time, around this time when the legislature learned that the public auditor had hired employees above step 10, even the director of administration has advised us that no matter how much she told the public auditor that this couldn't be done, the public auditor proceeded to do it anyway. And so it took the legislature to put into an amendment in the budget bill that would say any unclassified employee that's been hired above step 10, they would have to revert back to step 10, and they would have to, and if they don't comply, the consequence would be that they'd be deducted from their budget. And as we know, in following this situation, Madam Speaker, the public auditor challenged that amendment to that Budget Act and took this to court. And at the time, there were many people in the public that criticized those of us in the legislature that wanted to hold the public auditor accountable. And my position was, if she's going to be doing these audits on all the departments and agencies and finds that there's been a problem in how these directors have accounted for their public funds, then she should be held to the same standard. Because whenever we see individuals who don't follow the law, especially individuals that are tasked with making sure that all these taxpayer-funded programs are spent in accordance with law, this is a violation of the public trust. And so the public auditor proceeded to take this to court, and the court ruled that she has not been following the law, and the court further ruled that her budget shall be deducted by, I believe, some $40-some thousand that came out of her budget. So the court's remedy was that she would have to pay back the general fund from her budget what she supposedly spent that was not pursuant to law. So there was a remedy and there was a consequence paid. And as the retiring speaker said, there's also several employees. There are two of them that were found as a result of the public auditor's non-compliance to law. There are two of them right now, Madam Speaker, that are faced with having to pay this money back out of their own pocket. But more importantly, there are two of them. One already left and went over to the University of Guam, I believe. And there was one employee who is in this situation who the public auditor feels, and I tend to agree, that her credentials require her to be paid more than what she's currently making. And the public auditor finally agreed to go forward and try to request through civil service, through the Department of Administration, a desk audit to see if in fact these individuals, KSAs, will meet a merit increase. And so she's doing that. The one thing that the public auditor has lobbied this legislature for, and us individually, and is something I stood very firm, is she wanted her employees to be unclassified employees, when the law is very clear that the employees of the public auditor are classified employees. And she argued that she's elected, that she should have the ability to pick and choose whoever she wants to hire. Well, I told her that the Attorney General is also elected. And can you imagine if the attorneys at the Attorney General's office were all unclassified, and with the changeover of Attorney Generals, or in the changeover, in this case, of the public auditor, that all their rank and file employees would also be changed because they would be unclassified? And I don't believe that these attorneys, nor I especially don't believe that these auditors should be unclassified employees to be made subjected to do things at the will of the public auditor, to do things at the will of the elected public auditor, who has a political agenda and who has the authority to decide what departments get audited, what departments don't get audited. We certainly don't want that individual to have the ability or be in a position to abuse its power, Madam Speaker, to pick and choose and go after certain individuals because of certain associations and pursue certain witch hunts. And that's why I held very firm that the employees, and if I told the public auditor if she really cared about her employees, then she would want them to be classified and not unclassified, because their tenure in that department will last beyond that elected official's term, and that they would have merit protection, and that no one can hire them or fire them on the spot, because they would have merit protection and they would have job security. And that's just the opposite. She argues she wants job security for them and they should be unclassified. Maybe job security under her tenureship as a public auditor, but certainly not job security in the overall scheme of things. And so when I look at this amendment that's being offered by the good senator from Chalampago, on page 2, it just says that if there's any unclassified employee hired after October 1st, 2007, then that compensation for such employees shall be adjusted. I think it's not, I mean, it's a very artful way of recognizing that these employees have to be hired pursuant to the merit system. There's a reason why that's in place, and that it just says going forward, it does really recognize this court order. and it recognizes what we could do as a legislature to ensure that the public auditor is held accountable. And you remember at the public hearings when she came in to testify in this bill, she was extremely emotional, extremely remorseful. In all of our meetings with her, she just was taking a position that she needed to recruit these people. Well, that's exactly what people say when they get caught. They say, "I'm sorry, I shouldn't have done this. What can we do going forward?" And I think how I would want to address this situation is to still admonish the public auditor for what she's done, and she has no reservations about being called on the carpet with respect to the decision she made, but to make sure that going forward, those two employees don't have to pay back the government of Guam because they were in a situation where they weren't the ones who signed the personal action, and they accepted these job offers in good faith, and now for us to go after them and have them pay out of their pocket, for me is not the appropriate thing to do. And so I rise in support of Bill 208, and I still think that we have to recognize a victory on the part of the legislature that the amendment was put in the Budget Act to tell her to stop this. She went to court, and it was the court that affirmed the legislature's position that what she did and what she chose to do was absolutely wrong. She paid for that out of her own budget, and this Bill 208 is a good remedy moving forward, and so I rise in support of this bill.
Okay, thank you very much, Senator Respicio. Senator Guthers on the motion.
Thank you, Madam Speaker. You know, I've been following this matter for almost 2 years. And for 2 years, the employees at the Public Auditor's Office have been suffering the ramifications of unfortunate decisions that were made above them. And I agree with my colleagues. Yes, we have a dilemma here. But I would rather side on the dilemma of resolving this problem for those 3 employees, particularly the one employee that's still there, who didn't do anything wrong and who's undergone serious consequences as a result of what has happened. Now, I think there's a lesson to be learned here, and I think the Public Auditor's Office has learned the lesson, and I don't personally believe in the necessity for proving a point and keeping the effort to prove a point as long as it has gone on. I want to solve this problem for the employees who are innocent in this matter. So I support the bill. Thank you.
Thank you very much, Senator Guthers. If you have a point or anything, Vice Speaker, before I call on the author.
Yes, just as a point of clarification, I really have great concern, with all due respect to my colleagues, of trying to characterize these individuals as innocent spouses. These are certified public accountants. These are employees that when they've come to my office can cite to me line and verse and which code section applies verbatim when it applies to everybody else except for themselves. These are not innocent spouses. This public auditor used that excuse once before in a tax matter. And I don't think these employees, if we were dealing with a couple of individuals that were maintenance people who barely could read, that would be one thing. But these people know the law better than most of us in here, and if you've ever had them in your office discussing any of their audits, they can cite to you better than any law clerk that I've ever had. Section, volume in the code, and tell you where the mistake was and why they want the height of those people. And I really object to them being called innocent spouses because they're not. They have more advanced degrees than some of us in here and are certified. Thank you.
Thank you very much. that point of clarification. Are there any other speakers before I call on the sponsor then to close? Senator Palacios, you're recognized.
Thank you, Madam Speaker. Madam Speaker, again, the 29th Guam Legislature, whose members, most of them carry over to the 30th Guam Legislature. We already, it has agreed at that time to consider that and to make amendments and to not burden the two employees. And that is why if you look at section 2 on page 2, or rather beginning on line 12, this is actually current law. And if you were to read this, it is actually saying that notwithstanding all the provision of law, the Director of Administration shall adjust the compensation of unclassified employees who was hired above step 10 before the enactment hereof, effective the date of this enactment. I think at that time when we passed this, there was actually no one affected at the passage of that, because those that were hired at above step 10 complied with the standing regulations. They went to the Civil Service Commission, and that's why we had to adjust the date to reflect only those affected within the government of Guam, which is only 2, which is at the OPA. And so the proper date, instead of before the enactment hereof effective the date this enactment, actually the appropriate date would be after October 1st, 2007. Only those hired after October 1st, 2007 with this section would apply. And after that, then of course they're back in compliance now with the standing regulation. The hiring of those individuals is not proper in a sense that it did not follow established procedure. But there are procedures for the hiring of people above step 10. It was just at that time when the individuals were hired, the OPA actually believed, because she's an elected official, actually believed that she had the authority to hire above step 10. And so she made contact with these employees on the condition that they are to be hired at above step 10, which I think was the step 20. A GG1, a personal action, was cut. They were receiving it. This has absolutely nothing to indicate that there's some problem here, until it was brought up in fiscal year 2008 budget. I think I remember very well by former Senator Shimizu. Then that's when this thing surfaced and became an issue. And then finally we trace it, and it only actually affect the employees at OPA, because the OPA actually believed that she can do so, later on determined that she cannot. It has to go to the process. But the hiring of individuals above step 10, there are procedures that would allow that. The OPA did not follow procedures, and because of that, the determination is that the employees would have to pay back. There was a public hearing last week in which Nance, who is one of the public auditor that resigned and now working at UOG, she told me she received again a notice from DOA to pay back. That's what she told me. So as far as OPA is concerned, the DOA is concerned, they still have that authority to collect as long as the law is not amended. So this bill is to settle that on these two employees, and no more from here on forth, of course. They have to comply with the standing regulations for the hiring of above step 10, that only I think the Civil Service Commission can approve that. So with that again, like the speaker from Barrigada, I don't really cherish the idea of making exception here and there, but when these employees accepted this, they had no understanding, they had no idea that they are improperly assigned the above step 10. And so they accepted the position, and they perform under those conditions. So I ask my colleagues to at least consider this one time, Of course, a lot has been learned from this, and I do not believe that it had happened again after that, and I don't believe that it will happen again. Thank you, Madam Speaker. I move if we can make a move to put it on the third reading file for voting.
Thank you, yes. Vice Speaker, do you have another point?
Can I ask the indulgence of the members for a quick amendment? On line 15 then, since the body seems like it's going to be passing this, I'd like to make sure that somebody is held accountable. So on line 15, it should read, failure to comply with this section shall result in cross out de-appropriation of and put in place the public auditor being held personally liable for the total amount of compensation paid in violation from the budget of the for noncompliance.
That was a long sentence, so can you repeat it again?
Take out on line 15 de-appropriation of and put in result in the public auditor being held personally liable for the total amount of compensation paid in violation from the budget of the non-compliant agency. Or if that's too personal, then the director being held personally liable for the total amount of compensation paid in violation hereof from the budget of the non-complying agency.
And you do have that in writing.
Yes.
On the amendment, is there anyone who would like to speak on the amendment? Okay, please. You're recognized. You want to ask a question of the mover of the amendment?
I just wanted to make sure that if the intent is to have the auditor's name, and I understand what you're saying, it makes sense that, but if you don't specifically know the title of the individual or what the actual title is, then we would be, I mean, this would be, it would not, have any, how would you say, credence, because it's not the right title of the individual that we're trying to charge with if the amendment goes through. So I just want to make sure, with legal opinion, if we have to, if the technicality of that is to actually state the position title of the individual holding that, or because director, there's no director. The position of the public auditor is
Mover
auditor.
of the amendment, would you like
So
to
I'm just
respond?
asking. I'm just asking. If it's, can we take a 1-minute recess so I can ask legal counsel?
Okay, we're going to take a recess.
was to try to indemnify 2 employees. My amendment was to try to hold the public auditor, the certifying officer, personally liable for the expense. And if one refers to 4 GCA 14109, liability of accountable officers, A, strict liability denotes that the accountable officer is the insurer of the funds. B, an accountable officer is automatically liable when the loss incurs. Subsection 1. A certifying officer is not liable unless an improper payment has been made on the basis of the certified voucher. Liability arises automatically at the moment of the improper payment. 2. The liability of a certifying officer shall be enforced in the same manner and to the same extent as provided by law with respect to the enforcement of liability of disbursing and other accountable officers. A certifying officer shall be required to make restitution to the government of Guam for the amount of any illegal, improper, or incorrect payment resulting from any false, inaccurate, or misleading certificates made by the certifying officer, as well as for any payment prohibited by law, or which did not represent a legal obligation under the appropriation of funds involved. So we have one or two things: either go forward with my amendment or the bill is pulled because it's not necessary. Those employees are not liable for the expense. It's the certifying officer that's liable for the expense.
I'm going to take a brief recess.
Now there's the reinstatement of the strikeout in the bill is like restored, and then the October 1st, 2007, that's in the bill is stricken out in the amendment. I think that, when this came about, see, I understand that the past legislature already agreed to remedy the problem and relieve the employees of the burden. And the only issue standing between that is the date. And that's why that only those employees who were hired above step 10 after October 1st, 2007, which actually only the OPA employees, which are the only 2 employees. Last week, and
The legislature is back in session. The sponsor of Bill 208, Senator Palacios, you're recognized.
Thank you, Madam Speaker. Madam Speaker, with much discussion back and forth, I move that Bill 208-30 be returned to the committee for further consideration, and with the understanding, of course, that in the next session, I think probably next month, then by that time we would have resolved and come to an agreement so that whether we decide whether to move forward with this bill or to just withdraw it completely. Thank you, Madam Speaker.
Thank you very much, Senator Palacios. So with that motion, then, without any objections, so ordered. We are now on substitute resolution number 214-30. Senator Palacios, on that resolution, you're recognized.
Thank you, Madam Speaker. Madam Speaker, I move that resolution 214 be placed on the third reading file for purpose of discussion. If I can just give an overview.
Yes, please continue.
If you look at of course, the sponsor, the prime sponsor, I just followed what what past legislature had done with the similar resolution, actually requesting the United States government and Medicare to extend benefits for services rendered in the Philippines on non-emergency basis. Right now, Medicare applies only if a resident of Guam who is a beneficiary of Medicare is sent there under two conditions. I believe that the services cannot be provided here, and it has to be referred by Guam Memorial Hospital. Now, any other time, the person would not qualify. And the only difference now with this, of course, other than the major players are different now, is that this resolution recognizes also the need to provide copies to the Philippine consulate here. Why? Because we're actually requesting for Medicare to extend Medicare benefits, Medicare services and coverage for hospital in the Philippines that have been accredited under the U.S. standard. And that is actually the difference between this and the previous one that we passed, the legislature passed in the in the 29th Guam Legislature. And I asked my colleagues, of course, to support this. And the authors here showing it, they are the same. I just copied it all down. I like to take recognition, of course, of we're now 14 members, not 15, so one of the names would have to be removed. And thank you very much. Again, it is the same that what we have. This is more or less a resubmission to the U.S. Congress, and I think a copy is to the Philippines facilities. Thank you, Madam Speaker.
So on that motion then to correct, the number of members without objections to order. On the motion, Senator Frank Agun, you are recognized.
Thank you very much, Madam Speaker. I stand in full support of this resolution, and I think that with a good sponsor reintroducing it through the 30th Guam Legislature, I think it just emphasizes doubly in terms of the need for the federal government to perhaps look at this and provide some consideration. One thing that one information that I was able to acquire, Madam Speaker, is that this is not a new concept in terms of applying and allowing for Medicare to cover services being provided in the Philippines. As a matter of fact, our brothers and sisters to the north, CNMI, it's my understanding that they do, based on referrals, they do have the option and the opportunity to be able to be covered through Medicare for specialized services received in the Philippines. And obviously that's contingent on the referral being provided and if in fact the services are not readily available in CNMI. So this would be more or less requesting similar considerations in terms of allowing our people to be able to be covered with their Medicare payments to be inclusive of the Philippines. One of the things the challenges that many of our people, Madam Speaker, experience and go through is that obviously there are specialized services that are at this point in time not readily available and accessible in our local community. and perhaps looking at the long-term plan, those are areas that we need to be able to concentrate on and ensure that at least accommodations or arrangements can be made so that some of those specialized services can be provided to our people during intermittent time frames, if not on a regular basis. But in this case, I think it's only proper that if a similar accommodation is being provided to our brothers and sisters in the CNMI, and if in fact cost should not be a consideration when it comes to allowing our people who already are eligible and are participants of the Medicare program to be able to apply this same coverage to the services being provided and received in the Philippines, I think it's only appropriate that the federal government provides serious consideration. I want to also thank the good sponsor of the resolution for allowing me to be a co-sponsor, but I think it comes at an opportune time. Madam Speaker, we just acted on legislation or a resolution that would provide the sentiments of the legislative body as it applies to the military buildup, as it applies to the support that is needed. And I think that this is also one area that we need to share with the federal government and the federal representatives, that they should extend themselves and allow for Medicare coverage to be inclusive of the Philippines medical system. And if in fact the requirement would be you would have to be referred by your doctor here on island, I think that is not an issue. That's not a major concern, because obviously if the services are not available here, then it should be made available to our people regardless as to where they go. Our people travel to the mainland U.S., they get Medicare coverage through the facilities that are utilized there. Also, in this particular case, it will just extend the coverage to one of our neighboring countries, in this case, as is applicable in the Philippines. So I certainly stand in full support of this resolution, and I commend the good senator for introducing this and recognizing that this is an opportunity for our people to continue to receive beneficial medical services that are not readily available in our community at this point in time. So I stand in full support of the resolution, Madam Speaker, and I urge our colleagues to do likewise. Thank you very much.
Thank you very much, Senator Uga and Senator Guthertz on the motion.
Thank you, Madam Speaker. I too am very pleased to support the resolution. You know, on any particular day, my understanding from Guam agencies, health agencies, and private insurance companies is we have anywhere from 150 to 300 people from Guam obtaining medical services in the Philippines. And, you know, and this is every month. Yeah, this is overwhelming. This is a lot of folks that need medical care. Apparently that is not available to the extent needed here on the island. And these procedures probably are very complex procedures that involve certain surgeries that may not be conductible here in the community, as well as certain equipment that we presently do not have to deal with cancer treatments. I think our people should have that option to go to the Philippines if they want, or go to the States if they want, Hawaii if they want, to use their Medicare benefits. They presently don't have that option. Those of us who are familiar with the Philippines and even Taiwan and Korea know, and even Thailand, they're developing very, very high-class medical facilities. St. Luke's is building a brand new hospital in the Ortigas area to accommodate clients from abroad. Makati Medical Center, Asia Medical Center, all of these facilities are designed to be able to accommodate the diverse needs of folks, not just in the Philippines itself, but from abroad. So I would like to suggest that we all support this resolution, and that we do everything we can to facilitate the intent of this resolution. Thank you very much.
Thank you very much, Senator Guthertz. On the motion, are there anyone else who'd like to speak? Senator Pangilinan, you recognize.
Madam Speaker. You know, Madam Speaker, certainly rise in support of the resolution. And it's kind of a double-edged sword, because if we make it easier for our patients who have the ability to access Medicare insurance to go off island for health care, we're kind of shipping that money off island. But I think the recognition here in the request here is that the services that are not generally available on Guam would be made available to these individuals who decide and choose to get their health care from the Philippines. It makes it easier to go there, whereas in some instances, maybe if the individual was to only able to go to Hawaii, as they currently are under the Medicare program, or some of the stateside facilities, they may decide not to even do that. They may decide to forego that because maybe the health care is still elective or is not of an emergency nature, and so they'll defer that until some other time or some other arrangements. So it really is not that great of an impact with regards to shipping some of these healthcare dollars off island. But it certainly is within the right of these individuals who have earned, the key phrase here is entitlements. I mean, this Medicare is something you earn. It's not something that the federal government gives to you because they're just generous and benevolent. It is something that you earn and you pay for by virtue of working and being productive in the workforce and making your required contributions to the Medicare program in the payment of your premiums and your Social Security dollars during your time of employment. So it is health insurance really for those that have put into the system and are able to retire. And it really, one of the comments made during the hearing on this resolution in the previous legislature was, insurance really is you insure the person and not the place. And we see many, many instances where you kind of see those kind of restrictions with regards to where you can take your health care dollar and health insurance coverage and where you can get that care. And you make that voluntarily in terms of the contract you enter into. And so we understand the need to watch healthcare costs and so forth, but we also see that if it's a matter of cost, of trying to control cost, then it doesn't make sense to restrict the use of this healthcare dollar to stateside facilities because the cost of the service and the care is so much less expensive in the Philippines as it would be in Hawaii or the United States, continental clinics and hospitals there. So the argument that Medicare wants to ensure that they're able to control costs doesn't make sense when you relate it to the cost of that healthcare in the Philippines. Then there's the other argument maybe that Medicare wants to ensure the quality of care that is given and provided to its recipients and to its participants. And again, if I remember correctly, it doesn't make sense, and that argument rings hollow when the restriction that is being asked to be lifted are on those areas that are accredited hospitals by the Joint Hospital Accreditation facilities. So the Medicare dollar can only go to a hospital that has been accredited by a U.S. body as well as an international body that certifies and attests to the quality of health care and the protection of the safety of patients that are receiving care from that institution. So if it's not for cost and if it's not for quality control, then what is it for? Why does Medicare, in regards to the people living on Guam, restrict our access to health care in the Philippines? What could the rationale be? And I think that that's something that we really haven't even gotten a straight answer from. It's because that's the way it is. It's because we don't do it for other areas. It's because there's enough of a window of ability to access that care on an emergency basis and not on a regular basis, but you can access it on a regular basis if you come back to Guam and you get a referral and you go over there. But all of these kind of things just is not straight up. And that's what we're kind of trying to get here. Something straight up. Hofane, what is the problem with allowing employees who have contributed to Medicare, earn those credits, earn the the right to be insured by Medicare by virtue of their contributions through Social Security taxes, what is the problem of them being able to access health care that is insured with regards to its cost effectiveness and is insured with regards to the quality that's being provided under the terms that we're requesting for this flexibility that we're going to get. And they're allowing a greater flexibility for our cousins in the CNMI. They allow some greater flexibility for those that are living in the U.S. if they travel to certain countries. Why won't they allow us greater flexibility here on Guam? What is the problem? Hafay problema? Istine federal? It's just, sometimes it's so frustrating. But I think that what it takes is exactly what we're doing today. Is we don't give up, we keep going, we keep pushing forward, we keep asking our delegate to get the answers needed to us in order to justify and rationalize this denial of accessing the entitlement that we've earned and paid for under Medicare. And I can't see what rational basis there could be for this exclusion and this denial of this ability to access healthcare, something as fundamental as healthcare that is so important to the quality of the life that we lead. And the fact that we have a place so near to us that is so economical for us to get that care, and the federal government failing to see and understand why we want that flexibility. So I applaud the author, continue to support it as I always have since it was first introduced, and ask my colleagues to do the same. Sidusmasi, Madam Speaker.
Thank you very much, Senator Pangilinan. On the motion, Senator Frank Blas, are you recognized?
Thank you, Madam Speaker. Madam Speaker, I too would like to applaud the author and the co-sponsors for this resolution, for putting together this request. But as was expressed by the previous speakers, why? And I remember in the discussions that we've had in previous resolutions as well to the federal government, to the United States government, on things that why do we continue to have to ask for these things? Why do we have to continue to put resolutions together to remind our delegate in Washington of things that should be done? I remember specifically, I recall the legislation when it was discussed nationally about expanding Medicare coverage and entitlements, that it was provided, they extended it out to Canada and Mexico, that you had residents, the United States residents who went to Canada and Mexico, they can use their benefits there. And the discussion that we brought forth when that was going on, well, what about us here? Obviously, our borders aren't Canada and Mexico, but there's an area basically to the southeast of us, the Philippines, where veterans can, there's a VA benefit program that's there. There's a Medicare program that's there. As a matter of fact, right now, if you have a referral, it can be utilized. Why then can it be extended as is expressed in this resolution? Why do we have to ask? Why do we have to remind our delegate of these things? Was it not important enough then? Shouldn't it have been important enough then? Would it have been easier then to be able to obtain it? I don't know whether it's in the resolution here. thought maybe we should put it in a resolved here that not only did we just give it to her, that we basically ask her to submit the appropriate legislation necessary. So that it is discussed. Really, I don't see it in as far as the resolve. The resolve here. Request the support of the Honorable Madeline Guam Delegate to the House to aggressively pursue this effort in realizing Madam Speaker, I believe that let's make this language stronger. Let's make it so that not only does she in aggressively pursuing, we tell her, introduce legislation to be able to amend the Medicare Act so that it is included. So,
Would you like a minute recess?
can I have a minute recess so that we can come up with the language?
So
Thank you.
ordered. Legislature is back in session. Senator Blas on an amendment.
Thank you, Madam Speaker. And Madam Speaker, thank you for the opportunity to be able to take the time to not only to confer with the author, the main author of the resolution, but to come up with a language that I believe would provide specificity on what we want our delegate to do with this, with regards to this matter. And the amendment would basically be on page 7, starting on line 7, to strike out the words aggressively pursue this effort in realizing, and replace it with introduce legislation to grant. And it'll read to introduce legislation to grant the extension of Medicare healthcare benefits coverage. This is the one that should be representing the people of Guam, and the one that should be bringing the voice of the people of Guam to Washington, not the other one.
Thank you very much. Thank you very much. Senator
I won't say
Blas.
who. I won't say which colleague on the floor asked me to clarify that.
No problem at all. Besides, we wouldn't want you to
No.
be personal. So
No.
on the amendment, are there any speakers? Senator Agun on the amendment.
Thank you very much, Madam Speaker. Madam Speaker, I certainly stand in support of the proposed amendment to introduce legislation to grant the extension, but it's also my understanding that this also is reflective of a regulation. So really, it could be at her urging that she approach the federal oversight entity and require that they go through the AAA process and amend the rules to include and to allow Guam to be a direct participant. And I say this only because what I mentioned a little earlier. CNMI Medicare recipients already received this particular privilege, and just extending it and making an amendment in the rules and regs would be appropriate. So, but I stand in support of this amendment, recognizing that also there's an alternative avenue that the good Congresswoman can approach and take in terms of addressing this issue once and for all. Thank you very much, Madam Speaker.
Thank you very much, Senator Agun. On the amendment, are there any other speakers? Senator Blas, would you like to close on your amendment?
I think everything's been said, Madam Speaker. You know, unfortunately, this has to be a habit of this legislature, is we have to be able to spell out what we want our delegate to do and what she should do. You know, and is it high time? Probably. But I think this is most important, so we can put teeth and specificity as to what we want her to do. Thank you very much.
On the amendment, are there any objections? No objections, so ordered. Ooh, that was kind of heavy and loud. Okay, are there any speakers on the resolution, the substitute resolution as amended? There being none, so on the motion then to place on the third reading file without any objections, so ordered. Thank you. We're now on Bill number 218-30, and I recognize the author, Senator Tina Rose Mune Barnes.
As introduced and as amended by the committee, be accepted into the second reading.
It's already accepted as a motion.
Then motioned it to the third reading file.
And you want to speak?
Yes, ma'am.
Okay, you may continue.
Madam Speaker, this bill is an act to transfer properties under the jurisdiction of the Port Authority of Guam to the jurisdiction of the Guam Ancestral Land Trust Commission, so that this certain pieces of parcel will be given back to the original landowners, Madam Speaker. I'll just speak briefly on this. This August body found, Madam Speaker, that certain ancestral lands in the municipalities of Pt. And Sumai and Agate were condemned under Civil Action 5-49 by the Navy government of Guam, creating a Apra Harbor reservation boundary. And the United States, eventually, as time went on, the United States quit claim portions of that Apra Harbor reservations to the government of Guam, and in 1984, in December of 1984, and that eventually got transferred to the commercial port of Guam, and then eventually to the Port Authority of Guam for development. In formal conferences, Madam Speaker, between the Port Authority and some of the legislators here, the Port Authority had said there was no need for these parcels, and that they wanted to give the parcels back to the original landowners. And this is the premise of this bill, and I'm hoping that my colleagues will support me in these efforts. Madam Speaker, there were certain families that have come to several of our senators, even in the past legislatures, asking that their property that was given back to the government by Uncle Sam be given back to the original landowners, and they only want to be given back what rightfully belonged to their parents or their grandparents. And since there's no use for the government, that we ask that it go through the proper channel as created by legislation, that it go back to the Essential Lands Trust for the purposes of giving it back to the original landowners. So again, I'm asking that my colleagues support this effort, and that these parcels be given back. Thank you, Madam Speaker.
Thank you very much, Senator Gutherts, on the motion. Senator Gutherts, and then I have Senator Taitigui.
Thank you, Madam Speaker. I'm pleased to support the bill, but I do have one technical matter that requires some kind of clarification. On page 3, on line 2, there seems to be a word missing on that second line where it begins, the overlay shall something all original lot lines generally. So there's a word missing between shall and all. It's just a technical correction needed. I don't know what the word is.
On page 3, the overlay
On
shall.
page 3, the overlay shall something.
Show. Underscore.
Shall show all original lot
all
lines
original
generally.
lot lines generally. I have as amended by committee.
I don't have that one.
It's in your packet.
Madam Speaker, if I
Okay,
may,
so
I was
we'll
just
take
informed.
a brief recess.
Yes.
Oh, we're going to get it now? Okay. So was it I only got this one. Okay, no problem.
It's back in session. Senator Taitigui, you're recognized on the motion.
Seduce Masim, Madam Speaker. I stand in support of this bill, Bill 218. Any time that land is returned back to its original landowners, it gives me great happiness to see that and definitely support that. Though I do have some concerns, and I want to ensure that this bill doesn't have any problems later down the road. And I would like if the author would yield to a question that I have just to clarify something that's happened in the past where federal lands were given back to the government of Guam, thus having with them a revisionary clause attached to it. And I wanted to ensure that these lots do not have that revisionary clause or the ability to, on conditions that it be used for the port.
Would you like the chairman of lands to respond?
That would be good. Thank you.
Senator, do you yield?
And the question is?
And the question is is there any revisionary clauses where the federal lands were given back to the government of Guam, and that it's stipulated in there that it's only to be used for the Port Authority, and anything else would be reverted back to them?
Like almost all deeds that the government received from the federal government, almost every single deed has a reversionary clause regardless of when it was transferred. So this is no different than other properties that have been returned to the government of Guam under either the Excess Lands Act or the BRAC process. So it does, in my review of it, it does contain that clause, but every property that has been handed back to the original landowners under the Ancestral Lands Program, almost everyone also has the same reversionary clause. So it's not different from the others, and that's why we're treating it in the same fashion of the transfer through the ancestral lands in order to ensure that at least it remains consistent with how we transfer these properties back to the original landowners. So there's almost safety in numbers, you might want to put it, in terms of that every other return of property to original landowners, the original deed transferring those properties to the government of Guam had some kind of a reversionary clause.
Thank you very much. Does that answer your question?
Yes, it does. Thank you, Madam Chair. The other concern I have is with regards to the funding for the Department of Land Management to have this survey, putting in the aerial survey, plots and plans. And in this bill, I don't see any of the funding here recognized to be able to perform this task. And would like the author, if she can yield to the question, have they identified funding for this particular survey from land management?
Would the chairman again yield?
Yes, thank you very much. There is an existing survey division within the Department of Land Management that's able to do these surveys. The aerial plotting of the maps are done based on taking existing maps and overlaying them through computer programs, the CAD process. So really, there's no need for additional appropriation. The resources are there within the Department of Land Management to implement the plotting of these properties to ensure that the properties are returned to the ancestral lands with the proper metes and boundaries identified.
Okay. Thank you, Senator. That was one of my biggest concerns. I would hate to see that this go through and then have an excuse later down the line that they didn't have any funding to perform this survey map. Lastly, a biggest concern that I have, of course, is in the environment. And in that area, through the World War II ordinance, especially in that area near the military base where there is contaminants, toxins in that area. And I'm sure that once the landowners receive it, the original landowners receive that, will they have any vehicle or route to take in mitigating their properties to restore it back to its original state before it became polluted, toxic? And that is one of my concerns with regards to this, and I hope that if that does come about, that we can help these landowners to receive their land the way it was taken away from them in the shape it was before that happened. So once again, I stand in support of this bill, and I ask my colleagues to as well. Thank you, Madam Speaker.
You're welcome, Senator. On the motion, is there anybody else like to speak? Senator Uggan?
Thank you very much, Madam Speaker. Madam Speaker, I certainly stand in support of the legislation. Just wanted to, or I await the clarification in terms of the lot numbers, because if you look at the language, the original language, it reads portions of parcel 1 and 2 south of Route 18 and contiguous to the south of Apple Harbor parcel 6. And then the amended version would read contiguous to the north of Apple Harbor. So basically, there's a designation here that I need some clarification. And then if you continue on that particular paragraph, it says abutting Marine Corps Drive on the east, specifically original lots. It has 135, 136, 137, 159, 166, 127, 128. And then now the amended version would reflect 2 primary lots, which is original lots 159 and 159-1. I bring this up and I await the response and the clarification, because I'm sure that the Land Committee did an extensive research in terms of what the appropriate lot numbers are. And I only bring it up as an issue and as a concern because 3 months ago we had gone back into the books and had made a clarification or a correction on an Agana lot that was previously given out to a particular government agency, and apparently that was a private lot that was given incorrectly to a government agency. So I await the clarification on this, but I support the intent and the legislation itself in terms of identifying properties that rightfully should be given back to the original landowners if, in fact, this government of Guam does not need it for public beneficial use. So I certainly support this, and I await the additional comments in terms of the clarification, but thank you very much, Madam Speaker, for the opportunity to speak.
You're welcome. I think maybe what I would like to do here, Senator Pangilinan, if you don't mind, is to ask you allow you to speak now, because then you'll be able to provide a lot of this information that some of our colleagues may ask later. So Senator Ada, if you don't mind, I'll have Senator Pangilinan then precede you. Thank you very much.
Thank you very much, Madam Speaker. Madam Speaker, Bill number 218-30, as introduced by Senator Muñoz Barnes and amended by committee, would transfer a parcel of property that belongs to a single estate. The original bill that was introduced, in which the retiring speaker had noted all the different lot numbers that were crossed out, those are all other lots belonging to other estates. And when we had the public hearing, we were not able to certify, get all the information necessary to gather, reflecting all the limitations of those other estates and returning those properties to those estates as they work with the port master plan and the return of these properties. So what we did was we limited the effective implementation of a return of these lands to that single estate. So all the other crossed out numbers are other lot numbers that are not of that single estate that is being returned to the ancestral lands and ultimately to the original landowners. So, and we wanted to do that because we're very clear with regards to the testimony received by the port and of course by the author, that the intent was to return this one parcel to one estate in which we're clear on with regards to the ability of this property to be returned to that estate. There may be at some point where these other family members may come in and verify all of the information needed to act on them, and maybe somebody else might want to entertain that. But at this time, we did not want to hold back on the transfer of this property to the ancestral landowners, to that single estate. You know, there's a question on many different things as it relates to this. This is one case in which there are some properties that were returned to the government of Guam that remain in the hands of certain departments and agencies of this government. And in this one case, we were able to receive the cooperation, if you might call it that, from the Port Authority of Guam, that they were pretty clear that this wasn't figuring into their expansion plans, this wasn't figuring into their military buildup requirements for plans. There were some limitations on the development of this property with regards to its status as portions of it being wetlands, etc., that may be more expensive to develop. And in the end, the port at least testified that it was not included in their overall master plan as something that's being developable in the near future. And that near future is something as far away as 30 years, I guess you might want to call it. So the decision was during the public hearing to amend the bill to limit the transfer to that single estate, given that that's the most complete information we had. This is something that's been in the works for the last 6 years. And over the last 6 years, we've actually had a more concrete and definitive assessment from the Port Authority with the need for this property and the ability to develop this property to be consistent with the future needs of the Port Authority of Guam. And so that's why we limited it to this one single estate in terms of transferring this property to the ancestral lands. And I asked the colleagues for their consideration of this measure. Sidus Masi.
Thank you very much for that explanation. I'll continue on then with Senator Ada.
Thank you, Madam Speaker. I certainly rise in support of Bill 218 as substituted.
As amended by the committee.
Yeah, I'm trying to find the substitute copy. Thank you, my friend. I was at the public hearing, and I was there at the time when the acting general manager at the time, Rick Augustine, came in to testify. Also, the corporate manager came in to testify, and the question was asked to them specifically, is the land in question that is to be returned as proposed in Bill 218, is that land within the footprint of the modernization plan of the Port Authority of Guam, which right now takes a look out to the year 2030? And to that question, they said, no, it is not within the footprint of that modernization plan. During the testimony, the port, of course, was asking, well, can we then get a land exchange for that piece of property that's to be given back, the properties here in question, and to give us another piece of property? And they were looking at something closer over towards Cabras, where the power plant is. And the question was put to them, well, do you foresee needing more land out to the year 2090? And to that, it was really, the response was, well, you know, we just might need it. Well, the properties in question here have been sitting under the port for the past 50 years, and I guess they've been holding on to it for the just in case. I am satisfied and I feel comfortable that with the modernization plan that was done by and approved by this legislature, that the footprint of that modernization plan does not require any of the properties being proposed to be returned to the original landowners. So from that perspective, I certainly feel very comfortable in supporting this bill. I do have some questions, though, and and to make an amendment to the bill. On page 2, line 12, it reads, "The Guam Ancestral Lands Commission shall dispose of the land parcels and lots transferred by this act in a manner consistent with and pursuant to its enabling legislation and its mandates." If we just take a look back about, I believe, 10, 12 years ago, if you recall, the federal government returned what it deemed was excess land back to the government of Guam with the intent that Gov Guam would then return the lands to the original landowners. 10 years later, those properties were still within the inventory of Gov Guam. For whatever reason, valid or not, the lands were not returned to the original landowners until much, much later. So I, whether that's the good example to use or not, I would like to see that that time-specific, deadlines are in fact imposed, such that it would then read, "The Guam Ancestral Lands Commission shall," and add the language, "within 180 days dispose of the land parcels and lots transferred," etc. So in essence, from the time of the enactment of this property, then I guess the necessary paperwork needs to be completed within 30 days to turn the ownership over to the Guam Ancestral Lands Commission. The Guam Ancestral Lands Commission then will be given, with this amendment, 180 days to then ensure that it turns around and it signs the deed over to the original landowners. So in the earlier discussions, it was indicated that there is nothing that's going to require the hiring of surveyors that's going to cost thousands of dollars, and then we come back and say, well, we don't have the money to do the survey, but basically a lot of it will be a tabletop exercise to delineate easements and whatnot. So I would like then, Madam Speaker, to make that amendment on line 12, beginning with that sentence, "The Guam Ancestral Lands Commission shall, within 180 days, dispose of the land parcels," etc., etc. So that will be my motion, Madam Speaker.
On the amendment, okay, no objections, so
No.
ordered. Can you please provide a copy to the clerks of your amendment? It passes. It passed.
Oh, well, can the clerk just
Okay,
make
so
that?
we'll give it to you to sign then to initial.
Thank you very much, Madam Speaker. I have one other amendment to make, and that is in Section 4, we direct the Department of Land Management to plot, plan, design, and provide within 60 days of enactment an aerial overlay map delineating, and then to determine that such access, etc. And then on line 5, we say, on line 6, it reads, "This overlay shall be transmitted to the Legislative Oversight Committee of Pt.2 na Legislature ng Guam no later than 61 days after the enactment of the law." And I point to this particular sentence from the standpoint of, I thought that our purpose here was to establish policy. We want you to return that property back to the original landowners within 30 days from enactment of this property, of this act, and within 180 days, we want you to deed it over to the original landowners. We set the policy. Now, I don't understand, why do we have to get involved again? Why does that overlay need to be transmitted back to the legislature? For what? The overlay shall be transmitted to the Legislative Oversight Committee of Pt.2 Legislature ng Guam no later than 61 days after the enactment of this law. for what? And so I then make the amendment, Madam Speaker, to delete that sentence starting on line 6, which reads, "This overlay shall be transmitted all the way down to line 8. That, Madam Speaker, is my amendment.
On the amendment, Senator Pangilinan, you're recognized.
Thank you very much. Well, I have no adamant position with regards to the deletion. It's just easier for me to put it in here and to write them a letter and say, hey, what are you doing? Actually, it is follow-up. I understand we set policy, but I tell you, I probably do 5 or 6 letters a week asking all these departments and saying, hey, what are you doing with that policy? And so it's a check. For me, it's a way to ensure that the overlay map gets done. It's part of the process of implementing the policy. It's the same reason why, we put that we want it done in 180 days. I mean, if we didn't care, then we could just leave it open-ended. So it's the same reason why I think that, getting that map completes the record of the committee in terms of making sure we have the necessary movement towards achieving the 180-day factor. If they don't get it done in 60 days, then deeding it within 180 without the maps may not be achievable. So to me, it's just ensuring that the processes, that the implementation of the policy is happening, and we get an opportunity to track that it's happening. So, it doesn't matter whether that's in the law or not. I'll probably check with them. Hey, what are you doing, and how soon is it going to take you to complete the transfer of these lots? So that's the reason why it's there. It's the same thing that we require. For example, the Department of Public Works they should file the T-tip with the government of Guam, because that's what sets the projects that are by policy implemented by the Department of Public Works. I think that if we never get the notice, we never know whether the policy is being implemented. And so this is, again, part of that implementation of the policy that is needed to occur in order for it to get completed. So, so I guess I'll just object anyway. Okay, thank you.
Thank you very much. On the amendment, are there any other speakers? Would you like to close, Senator Adao?
Yes, Madam Speaker. I think we got to get out of the business of trying to play managers. That's why we have that guy down at Adelup, to let him follow up on his directors who are supposed to be managing, who are supposed to be making sure they're carrying out the mandates that have been passed by this legislature and also enacted into laws. So I only put that in there because I really think that we need to get out of the business of being managers, and let's stay with the business of being policymakers. Thank you, Madam Speaker.
Are there, okay, no. Since there is an objection, I'm going to call for the vote then. Those in favor of the deletion of that last sentence on line 6 to 8 on page 3. All those in favor of the deletion, please raise your hand.
He's not here. Palacios is not here.
Can you call Senator Palacios and Senator Guthertz and Senator Agun? Much, colleagues, for coming in. On the motion then, which is on page 3, lines 6 to 8, to delete that last sentence. And there is an objection, so all those then in favor to delete the 3 lines beginning with this overlay in line 6 to line 8. All those in favor, please raise your hand. Okay, motion carries. On the motion then, are there any other speakers before I call the author to close? Anybody else? None others? So therefore, Senator Tina Rose Munoz Barnes, you're recognized to close.
Thank you again, Madam Speaker. I'd like to thank my colleagues, Madam Speaker, for sharing and tweaking the bill to make it even better. But I do just want to make a minor change before I ask to move this down for the voting. Is that on page 2, line 2, after the word properties to the, and then it says GALC, so that the GALC, I understand I don't have anything before that saying the Guam Ancestral Lands Commission, so I just want to go ahead and do that technical correction before I use the acronym. Or do I need a motion? Okay. The clerk's shaking her head saying the motion's needed.
The
on
first
GALC.
GALC to spell out what it
Yes.
means, okay. On that motion then, without any objection, so ordered.
Thank you again, Madam Speaker, and I thank my colleagues and continue to ask them for their support on this Bill 218.
So then on the motion then to place down in the third reading file without any objections, and of course, the bill number 218 as amended and then by committee and further amended on the floor. Without any objections, so ordered. Thank you very much, Senator Tina Rose Munoz Barnes. We're now on bill number 236-30, and I want to recognize the chairman of the committee. The chairman of the committee, which will be, is not here, so then, we'll go ahead with the second co-sponsor and also then to Senator Tina Rose Munoz Barnes would.
Madam Speaker, move that Bill number 236-30 COR has introduced an act to amend subsection 6217 of 4 GCA for the purpose of ensuring that night public employees that the work at night receive night differential pay be moved to the third
And you'd like
reading and
to speak on it? I think the first amendment you have to make then would be that that you be the primary sponsor.
I have no problem with that.
On that
Madam.
motion then, without any objection, so ordered.
Madam Speaker, if I just may briefly, this August body found that working beyond the confines of a normal 8 to 5 day places a lot of significant stress upon a worker and their families, and we also find that as parents are kept away from their children during critical family time, the legislature finds that employees that are required to work during these family and unfriendly hours should be compensated for loss of quality time for their families. And it's really asking, Madam Chair, that for those public employees who work at night after the usual 8 to 5, that they be given and receive the night differential pay. So I ask that my colleagues support this, and I know that with that, the families who go through these trials will be given a little bit more reprieve. So thank you, Madam Speaker.
On the motion, are there, Senator Talataytike, you're recognized.
Thank you, Madam Speaker. Madam Speaker, this bill was brought to us at another time, previously at another session, and there was an amendment that was made, and I'm not quite sure, but would that amendment apply to this one as it's being presented? So I would
No.
have to move to have an amendment that I have here that I once again will get a copy of to my colleagues if you allow me a recess. But before that, a short break, I'm sorry. But before that, I still have not received any fiscal note with regards to this bill and showing the impact on the general fund, especially since we've already passed a 2010 budget, that how much this would additionally cost the general fund. And I would like that first to be brought up before we continue on.
Okay, we're going to take a brief recess. The legislature is back in session. There was a question that was brought up by Senator Taitui on providing a fiscal note for all of the bills that may impact the budget. Senator Respicious, the chair of the rules, I understand that you have some communication to BBMR.
Thank you very much, Madam Speaker. Madam Speaker, in our November session, we had 35 bills on the session agenda. At that time, Senator from Chalampago raised the issues of fiscal notes. And as you know, although it's a statutory requirement, even the BBMR director confirmed that this is the most widely unrecognized statute, a statute that she was a part of creating when she worked for a former Ways and Means chairman here in the legislature. But she said that if this legislature is going to recognize this statute, she would do as much as she can to require that any bill that passed that November session would at least either have a fiscal note or be given a waiver from the BBMR director. Of the 35 bills, Madam Speaker, I believe there are like 19 bills that the BBMR director and her staff diligently reviewed and turned over in a day or two working days to require that all of these bills that we passed during that session did meet the fiscal note requirement. This particular bill in question, although a fiscal note was requested, it was also subsequently referred back to committee at that time. And so the BBMR director did not include this as one of the priority bills to do an analysis of. But technically and legally, if a fiscal note is requested and the BBMR director does not respond within 14 days, and the waiver is automatically granted, and that the bill would meet the statutory requirement to be addressed by this legislature. And so my recommendation is we can argue the merits of this bill. I'm fully prepared to articulate that the fiscal impact to that agency is similar to what the fiscal impacts are in respect to how these directors deal with their overtime. Overtime, Madam Speaker, is hardly a budgeted item, but when these directors are strapped for the need to have manpower, they pull these people and they take from within their agency's budget, or the governor transfers, or BBMR identifies additional resources to make sure these employees are compensated. The bill before us and before this body deals with how we treat our employees, and this 4-hour minimum work requirement in order to start receiving night differential is just not right, as expressed by the proponents of this legislation. If an employee of this government works 1 minute over 6 p.m., that employee should be compensated night differential from when that clock starts ticking. And so what the practice is they make them work 2 or 3 hours, then they release them. And this is what this bill reflects, and this is where the argument is at. But if your question is, does this bill meet the statutory requirement to be addressed by this body? As Chairman on Rules, I'm declaring that it does. And I thank you for giving me an opportunity to explain.
Thank you very much, Senator Respicio. Senator Taitigui, you still have the floor.
Thank you, Madam Speaker, and to my colleague who explained that. But necessarily, I mean, if each of us were to stand up here in front of the mic and say, is this going to impact our general fund? Did we appropriate this money in our 2010 budget? And if anyone can stand up here on this microphone and say, no, it won't, then I have no problem passing this. But we have to start being accountable for the money that's given to us by the confidence of the people of Guam, that we're going to spend this correctly and stop spending money we don't have. If we're going to put legislation through, then we at least find the monies that can do that to support any bill that we put forward. The excuse for Bibi Ahmad not to have a fiscal note for this, what is her reason? What, she didn't have enough time? It was not important? This is very important. We need to know how much this is going to impact our general fund, and do we have the money to do so? I asked Madam Speaker, that we take this and take it back to committee until we get something solid, confident, and when we vote for this. It's important to address the issues of those individuals who do work overtime. I have no doubt about that, and I definitely support that. But I don't want them coming back and saying, we never got paid for something that we should have gotten paid 2 years ago, 3 years ago, and that's always coming back to us. Let's start being responsible for the people of Guam's money. Thank you, Madam Speaker.
Senator Taitigui, are you making that as a motion?
I'm making a motion to put it back to committee until we get something a fiscal note that we can all stand and consciously vote on.
There is an objection, so therefore, can we call the other members in? Can somebody please call for Senator Gutherts? I know Senator Tenorio left for a medical appointment. I understand we're unable to reach Senator Guthers, so there is an objection on the Taitigui amendment, which is to send Bill number 236 back to the committee. All those then in favor of that motion, please raise your hand. Senator Taitigui, you vote for your amendment? Okay. It failed to get the required votes and to pass. Senator Palacios then on the motion. Oh, I'm sorry, did you have another? Oh, I'm terribly sorry, Senator Palacios and Senator Taitigui.
Si dus, Madam Speaker, Madam Speaker, as before, I introduced an amendment for Bill 236 with a great support. It did pass the amendment, and I would like to proffer this amendment again to the floor for Bill 236. And this is all agencies opting to pay night differential pay identified funds to implement any night differential pay. Any agency that is unable to identify such funds shall not schedule regular working hours for any employees between, and this is where my amendment comes in, 6 p.m. to 6 a.m. or required by any employee to work during such hours. In the original bill, it had from 6 p.m. to 7 a.m. And if you look, Madam Speaker, in all federal agencies, they have maintained that same hour from 6 p.m. to 8 a.m. And I ask my colleagues for their support on this amendment. This is located on the second page.
Can you please clarify, your bill said 6 p.m. to
Yeah,
6
it's
a.m.?
basically, it's
But you
changing.
You said 8 a.m.
I'm sorry. Apologize. For all periods, the original bill says work between the hours of 6 p.m. to 7 a.m. on the original bill, and my amendment is to change it from 6 p.m. to 6 a.m.
And you're adding the other language ahead of it.
Yes,
about
and I did
agencies.
pass my amendment out for all my colleagues to view. And once again, this was passed by my colleagues, the amendment, when it first came to the session. Thank you, Madam
On the
Speaker.
amendment, are there any speakers? Senator Palacios on the amendment.
Thank you, Madam Speaker. Madam Speaker, during budget process, agencies already identify night differential under the title, of course, special pay. And that comes in the night differential and so forth.
Point of order, Madam Speaker.
Please state your point of order.
I thought there was a motion to send the bill back to committee.
And it failed.
Oh, okay, all right, thank you.
Okay, Senator.
And so that, and for any other agency to actually identify, I guess, to the dollar, it's going to impose some kind of difficulty in the management, the operation of the agency, specifically utilities agencies, of course, nurses, those professions that work at night on a 24-hour basis, of course, the police department and so forth. And so, again, there's a current law already that provides for the compensation of government of Guam employees that work at night between the hours of 6 p.m. and 6 a.m. But I'm speaking whether an agency has money or not. Once the employee in that agency work night time, the employee is entitled for compensation. And again, it's best left to the agency to determine. Of course, the agency will determine if there's funds to pay, but overriding consideration in this is whether the work needs to be done during night time. I think that should be the overriding consideration. And if that agency finds itself in a situation where it has to deploy personnel during night time but has not opted at the budget hearing to pay night differential, then that agency, by that, if this were to pass, would not be able to deliver that service. I think as it is right now, the current law is sufficient. Again, the bill before us is essentially saying, and that is to correct what appeared to be inequity in that if an employee works short of 4 hours, short of 4 consecutive hours, then the 3.5 hours would not be entitled to night differential, even though if the employee works at 6 p.m. and gets off at 9:45. So this bill is saying no more of that. From here on forth, anyone who has worked even 1 hour, the first hour, is already entitled. And that is what this is all about. Well, the law enforcement, that anyone that worked beyond 4 hours, and most of them recognize that, they're already drawing night differential. They are. But this one, like I said, is to correct what appears to be unfairness to those employees, that they cut off 15 minutes to 4 hours. and you're not entitled, or they break it up and 2 hours and then go home and then come back, because the current law says you have to work 4 consecutive hours. So there appears to be, I guess, a manipulation on part of management, and I wouldn't be surprised if that's happening, to shortchange some of these employees. And I think that when a person is in work 1 hour, the first hour, during the hours of 6 p.m. and 6 a.m., that person should be compensated in that differential, Madam Speaker. And so this amendment, in my opinion, it's not necessary, because here we deal with the entitlement to pay night differential, not whether the agency is entitled to pay individuals that work at night. The agency has no authority to withhold night differential pay if that employee works night time. Thank you, Madam Speaker.
Thank you very much, Senator Palacios. On the Title III amendment, Senator Respicio, you recognize.
Thank you very much, Madam Speaker. Madam Speaker, you know, I understand the reason behind an amendment like this, but I also am worried about unintended consequences. You know, as a previous speaker said, when you look at the law enforcement agencies, GPD, Fire Department, DOC, DYA, you look at these agencies, they do have certain shift workers that are budgeted for night differential. Some directors have actually been proactive and budgeted for overtime. But if you are a director of one of these agencies, Madam Speaker, you cannot really predict if your shift worker is going to come in at exactly 6 p.m. So what you might have is your 5 p.m. workers being held over. I mean, anyone who's involved in these kinds of 24-hour day, 7-day-a-week operation, and not a 8 to 5 government-run operation might understand why this provision would handicap that agency and hamstring those directors that have to do what they need to do to require those kinds of mandates that are being delivered to the people of Guam. What do you do in the case of the Department of Youth Affairs if your 6 p.m. worker comes in at 6:30, but your shift worker that ends at 5 p.m., you can't ask them to stay another hour to cover someone who's just running a little late? And then what do you do by adding insult to injury? You tell that employee, yeah, even though you worked a night differential, even though you worked after 6 p.m., you didn't work a minimum of 4 hours, so we're going to send you home and you're not entitled to night differential. How much more are we going to ask of our GovGuam employees to keep covering those kinds of shortfalls and not go after the justice here to make sure that they're compensated? And I appreciate the debate, but the debate about whether or not this is budgeted, I think it's a red herring. Perhaps the administration would not want a provision like this to be amended because you might have those directors who abuse their employees, who make them work for 3.5 hours, and because under this law, they send them home and say, I'm just sorry, the law does not authorize me to have you get night differential. Earlier, I heard a statement, and I support an amendment based on that statement, that we have a guy at Adaloop and let that guy do its job. Let him do his job. And to have an amendment like this goes against the grain of that kind of thinking. This amendment basically says that if an agency is unable to identify such funds that shall not schedule regular working hours for any employee between 6 p.m. and 6 a.m., or require any employee to work during such hours. What happens in the case of the emergency room of the Guam Memorial Hospital? What happens when those shift workers don't come in on time? And we all have family emergencies. How many of us have perfect attendance, or how many of us come to work on time? And that same thing can be said throughout this government of Guam. There are extenuating circumstances where employees don't come to work on time. And then you can weed out those that just are habitually late or absent, and then you can deal with those in a disciplinary fashion. But what happens to a nurse who comes in late because their son got sick? Are you going to tell the employee who's supposed to be off at 5 p.m. that I don't have the budget to pay you night differential, so we're going to have to shut down that particular unit of the emergency room? This government doesn't operate that way, and I understand the need to be fiscally responsible. but I also understand the need to hold our directors more accountable and let them be the one to proact for these kinds of emergencies. When I was at the Department of Youth Affairs, Madam Speaker, I was able to look at our staffing pattern. I was able to look at our work plan. I was able to determine, based on the number of employees we have, where our shortfalls will be. And based on our shortfalls, what kind of budgetary resources we have to require any overtime requirements or to require the payment of night differential. Government it's not a perfect kind of system where you can project and you can predict all these things. Even the overtime that's budgeted by these directors, these frontline agencies, DOC we see has a lot of overtime requirements because they don't have the necessary number of personnel in order to avoid these kind of overtime requirements. So, you know, for me, I'm approaching this bill as a matter of policy. And the policy for me should be that if your employee works 1 hour after where it's considered night differential from 6 p.m. to 6 a.m., then that employee should be entitled to night differential. And stop working these employees 3 hours and 59 minutes and then sending them home. You know, that's just not how our government should operate, notwithstanding the argument as to whether or not these things have been budgeted. Sure, night differential for these certain circumstances may not be budgeted, but the governor has transfer authority. BBMR can look at these deficiencies. And to the defense of the BBMR director, because this bill was sent back to committee, I never really followed up with her to see from the remaining bills whether or not she can do a fiscal note. The fact that we requested one and she provided a fiscal note on the bills that we were going to address at that time. And to her defense, Bertha Dueñas is an absolutely competent person, Madam Speaker. And sometimes when we're looking at things on a daily basis, our priorities shift because of the emergencies. You can imagine what kind of emergency someone like her goes through on a daily basis, given the present fiscal condition of our government of Guam. So I understand what this amendment is trying to do. I object to this amendment because of the unintended consequences of probably shutting down these vital functions of the government of Guam, or even those kinds of directors who may want to have their agencies be open from 7 a.m. up until 6 p.m. or up until 7 p.m. just to have greater access to the public. And so in those kinds of instances, I'm sure the director can be able to just determine whether or not he can afford that budgetarily. But in this case, it's basically saying if you can't identify the money, you can't make that person work, then you won't have the ability to deliver that service. And in the areas of critical services to the government of Guam, this might just hamstring those particular directors, and I can't rise in support of something like this. Thank you, Madam Speaker.
Thank you very much, Senator Resticio. On the Taitagui amendment, Senator Pangilinan, you recognize.
Just want to see, Madam Speaker. Madam Speaker, I rise to say that I guess maybe the amendment doesn't account for what happens in these situations and has not followed, I guess, the budgeting and the scheduling process. In reality, you always have budgeted, if the budgets are done correctly by the departments and agencies, for those departments and agencies that have shift work, every shift work, whether it's the regular hours or the night differential hours, night differential is budgeted for those. So if a person works up until 6 p.m. and is supposed to go home, his replacement or her replacement that's going to come in to work from 6 to 3 or 4 the next morning, whatever, that person is budgeted for night differential if they do their budget right, which we looked at, and the departments and agencies, for example, Department of Corrections, GPD, excuse me, Youth Affairs, and in those areas that run those 24-hour operations, those departments actually built into their budget the night differential. The problem is that in some instances, what happens is So if the person's replacement doesn't show up, that person that is supposed to show up, if he shows up and works beginning at 6, he gets night differential. If he doesn't show up until 8 and that person stays and works the 2 hours, then he just takes the night differential pay from that person that should have shown up at 6, who would, had he shown up at 6, would be paid the night differential. So he doesn't get paid those 2 hours. It goes to the other person, and the night differential is built into that 2-hour shift. But what happens is, so when the guy shows up at 8, they send the guy home who's worked those 2 hours, and then they don't pay him the night differential. But it is budgeted for, because that person, had he shown up from work, would have been paid it. So it just goes from the person who shows up, who stays, the money that goes from the person who doesn't show up, it goes to the person that stays. So in that respect, you have this, that it is built into the budget. Now, it depends on how often it occurs and so forth, and you may have some instances. But it really is there already when you look at it from that budgeting and the ability to pay perspective. The problem is that it's inherently unfair that happens. Or for example, when they say, have you stay, and you stay for 2 to 3 hours, and then they tell you to go home, because they're just going to leave that shift uncovered and they're going to shift everybody else around because they don't want to pay you the night differential, or they're going to cover it from existing staff that stays over. And so you're out of luck now because you've waited for 3 hours, you've done the work that that person should be doing, you've done it in the time in which the federal government was saying, oh, the federal government does this. Well, the federal government requires. It's not a matter of opting to pay night differential. It's a matter of requiring to pay night differential. And I guess the way you would say where the opting to pay is that you opt not to pay it and to basically cheat that employee out of that night differential pay, because you're now saving that 3 hours of not paying him the night differential even though he worked for it because that person didn't show up. So the guy worked. He worked the hours that qualify for night differential pay under the Fair Labor Standards Act. And if he worked it, pay him. And the person who didn't come in, take it from what you budgeted for their salary had they worked at the beginning of their shift, and pay this guy that stayed over. It's pretty simple in terms of the mechanics of transferring. There may be a little bit more hard work and administratively doing it, but it's there so that you can account for this thing, you can plan for it, and it is planned in the initial budget process, in that these departments and agencies that run these 24-hour shifts do provide the night differential pay for those for those hours that are covered under the Fair Labor Standards Act as requiring night differential to be paid. It's just that we have our own local rule that says you got to work 4 hours in order to qualify, even though the hours you worked are covered as night differential compensatable hours. But you don't do it because of the local law that exists. And we think it's an unfair law. It's not employee friendly. It's management friendly in terms of you're giving the discretion of management. And believe it or not, we all know what happens in the government of Guam in terms of those that get it, those that don't, those that, we look at what happens when somebody's tight with management and not tight with management because the person stands up for their rights and asserts their rights of what is due to them, that he gets labeled to be uncooperative, and so they send him home 3 hours later and he doesn't get paid. But the guy who is cooperative, they have him stay another hour so they can pay him and then send him home. And we want to eliminate any kind of discretion that would be detrimental to the interests of the employees. And I think that this bill is detrimental to the interests of the employees. And I don't believe it's employee friendly. I don't think it looks out for the common man. It looks out for management. And that's just not where I stand on this issue. I stand on the side of the employees and not on the side of management, because there's too much discretion there. And so that's why I say I believe this amendment is unnecessary. Thank you.
Thank you very much, Senator Pangdon. Anybody else who would like to speak on the amendment? There being none, Senator Tite to close.
Thank you, Madam Speaker, and I do appreciate the sentiments from my other colleagues. And just to make it clear, I am in support of this bill. It's a matter of two things. Changing the time that reflects from 6 p.m. to 6 a.m. instead of 6 p.m. to 7 a.m. And this is done in other federal agencies. The part about employee-friendly, administrative-friendly, there's no question about my feelings toward this as employee-friendly. But at the same time, too, we also have to hold our directors, our administrators, accountable. As one of my colleagues stated earlier, holding our directors accountable. How many times has the newspaper brought out saying that there's going to be a payless payday? Because the directors, the administrators were not able to add up right. This simply puts these individuals accountable whenever they're putting anybody out there that's going to receive, that's entitled to night differential pay. That's all this does. It makes them accountable. As far as the waiver on the fiscal note, that's the responsibility of Bertha. That's what we pay her. That's what the taxpayers pay her to do. It's too hard a job. She has too much on her plate. Well, I'm pretty sure she has a full staff to help her out when it comes to this. Something that's very important. Right now, Madam Speaker, we're facing a shortfall. A shortfall of almost $14 million. Oh, 16. I apologize. Thank you for that correction, Madam Speaker. We must be accountable for the people of Guam's money. But most especially, those individuals that come to work from 6 a.m. to 6 p.m. to ensure that they get their pay too. That they're not worried they're not going to be able to get a paycheck. Where a lot of individuals work, they receive paychecks and use that up and wait for the next week and use that one up. They're going from payday to payday to survive. And even the 1 ounce of a threat of a payless payday will set them back. Once again, I stand in support of this bill, but we need to be accountable. And I ask my colleagues to reconsider. I do realize that my good colleague from Agana Heights, I was going to say Chalampago because he was a neighbor, but Agana Heights explained about the situation for public safety purposes. An answer to that was my good colleague from Barragata, who explained, if someone doesn't show up on time and that individual employee has to stay a couple more hours, well, guess what? That individual employee will receive night differential pay. With this, yes, I stand in support of this, but this bill will allow that to happen. But my amendment, what I'm speaking on the amendment, is to be able to identify the funding that's going to pay any night differential that has not been equated in the budget. Can we honestly sit here and say without a physical note that it's not going to affect our general fund? I'm pretty sure if you put your right hand up and say that this will not affect, your right hand up, you're the one.
Senators, Senator Tyree has the floor.
Thank you, Madam Speaker. Please, my colleagues, reconsider this. It puts our directors in a situation they have to be accountable for. They have to cross their T's and dot their I's. Subtract, minus, add, divide. It makes them accountable. I wouldn't mind if anybody put something in here that said if they don't have the fund, it'll come out of their own pocket. But please, colleagues, We are already $16 million short. We have to think of those individuals that work right now who go paycheck to paycheck and not given them the anxiety, not to give them the anxiety every time, 2 days before payday, are we going to get paid? Thank you, Madam Speaker.
Point of order.
Please state your point of order.
Thank you, Madam Speaker. It appears the amendment seeks to accomplish two things, so I move to divide the question. One amendment being to change the hours from 6 p.m. to 6 a.m. Rather than how the bill reads, 6 p.m. to 7 a.m. And then the next amendment would be whether or not the director will identify the funds or not, if the author is okay with that.
Well, we can't divide this particular amendment. I think I would entertain a separate amendment and to change the time after we're disposed of this amendment.
Okay.
So then on the motion, you're right, Senator Barnes, you objected, right? Is that correct? Oh. Okay. Okay. So there is an objection or our objection, so I'm going to call for the vote. Those in favor of the Taitagwe amendment, please raise your hand. Sorry, the amendment failed. The other amendment, Senator Taitagwe.
Okay, thank you, Madam Speaker. Then I move that another amendment, and just on the second page, to strike out 7 a.m. to put it at 6 a.m.
On the amendment, who would like to speak? No, this
No,
is
this is
separate.
a new amendment.
This is just only on the time. No, that amendment failed. No, there's a separate amendment. Senator Ada, on the amendment?
Madam Speaker, I rise in support of that amendment to really shift it back to the 6 p.m. to 6 a.m. period. Quick search on the internet, shows that conventionally the time period from sundown to sunrise is really the period that is customarily used for establishing that working period where night differential will be paid. But quite frankly, in addition to, that's the way that's kind of like saying that's the way we've always done it. And I say, yeah, that's the way it's always been done in the industry, in the private sector, even in the federal governments, from 6 p.m. to 6 a.m. And if we're just going to be arbitrary about it, then, well, what the heck? Then let's change it to from 6 p.m. to 8 a.m. because that's when the 8 to 5 crew comes in. And we'll know then that these employees will still be around for when the next shift comes in. Earlier the amendment or the motion was made to pull this bill back to committee to really look at it closer because on the one hand, I think that the amendment here about striking out that requirement for a minimum of more than 4 consecutive hours before the night differential kicks in, I fully agree with the deletion of that particular aspect of the law on night differential. But, we take a look at the GCA, this is it. This is it about night differential. And I'm surprised that, I think we should take the time to take a look at, for example, what if an individual's work shift is from 12 noon to 9 p.m.? Now, is he entitled only to that 3 hours of night differential from the 6 p.m. to 9 p.m.? Otherwise, if you take a look at other, the organizations of human resource management, even some of the federal regulations here, it states that if the majority of the work hours, for example, in this case, if the majority of the work hours is not in that night differential time block, then those 3 hours are really not eligible for the night differential pay. So in this case, it will be from 12 noon to 9 p.m. at a straight pay with no premium of 10% added to it. Then you take the other situation where the individual is asked to come on at 5 p.m. in the evening, and he doesn't get off until, 9 hours later. So do we pay that individual then the 10% night differential from 5 p.m.? From that 1 hour from 5 p.m. to 6 p.m., when in fact the majority of his work shift is in that night differential time block. And a lot of, again, you make references to the Organization for Human Resource Management, a national organization, and they would argue that 1 hour, in fact, should be eligible for the night differential pay. And so, it's instances like this that I really, I guess you can't make the motion because it's already been made once to pull it back to committee. But I guess first of all, there's the motion on the floor to amend from 6 to change the night differential work block from 6 p.m. back to 6 a.m. as it is in the law currently. And that part I would rise in support. But I would also ask my colleagues to seriously, if we're really going to fix this night differential so that we bring justice and equity to our employees, maybe we need to do a little bit more work on this particular issue and not treat it so simplistically that it's just a matter of changing it from 6 a.m. to 7 a.m. or whatever. Because there are really other cases where we probably should consider that our hours outside of that 6 p.m. where the start time of the night differential may probably be very justifiably eligible for the night differential. So to the question of the amendment of changing it from 6 p.m. to 6 a.m., I rise in support of that, Madam Speaker. And I would say that unfortunately I will not support this bill because I think it needs a little bit more work. It needs a little bit more attention to detail so that in fact, if we really want to treat the employees equitably, then we really should do a better job at it. Thank you.
Thank you very much, Sanchada. On the motion, are there any objections? You object? Okay. On the amendment, which is from 7 a.m. to 6 a.m. No, you're right, and that's, yes, he's objecting to the time change. Well, I've been considering that for everyone basically this afternoon, and I will continue with it. So therefore, I will recess until tomorrow morning at 9.